Good afternoon, everybody, and welcome to the June Q&A virtual lunch hour with Jason Killeen. I just want to welcome everybody um, to today's Q&A session. Today, I'm going to do a brief overview of the update to the rules and regulations before we go ahead and jump into the questions. And our team has prepared a few slides for you guys. So our rules and regulations for cannabis procedures were updated on May 30th of 2024. We do periodic updates to the rules and regulations. This set of updates were to align some of our local policies with state policies based on what we've been seeing from some of the compliance inspections that have happened earlier in the year. So for Regulation 5, a major violation was added for relocation modification that's performed without DCR's approval. You can't relocate without first going through a formal process with DCR in the state. So licenses can't be transferred separate and apart from the existing location license was issued. And you do have to demonstrate that you can meet the licensing requirements at the new location before you can start to operate there. So in lieu of citing folks for unlicensed commercial cannabis activity and basically preventing them from engaging in the regulated market, we have created a violation to allow for us to deal with it within the context of the regulated market. One of the other regulations was previously the rules and regs prohibited cannabis goods from being displayed in a place where it's visible from outside of the business premises. That was legacy language from 2017, based on kind of how the state's original regs were. So we've removed that. So of course, cannabis goods can be visible from outside of the business premises. Retail storefront licensees are allowed to do curbside delivery. That was something that the Department of Cannabis Control implemented during the pandemic, and the state legislature and the DCC have made it a permanent regulation. So our retail storefront licensees, may have curbside pickup locations. You just need to make sure that you're following state regulations. And then for the motor carrier permit, in our rules and regs, it was a requirement for distributors and non-storefront delivery licensees. The state does not require it for folks that have a delivery license that they're doing deliveries to consumers. The state only requires it for the distribution activity where the cannabis is moving from business to business. So we did remove the motor carrier permit for non-storefront delivery licensees. Regulation 6 was updated so that folks who are part of a social equity application record, specifically the social equity individual applicant, needs to have a successor and interest form on file with the DCR. So it can be submitted as part of the annual renewal cycle if one is not on the file or if there's an update to it. That's important in the event of the death of the social equity individual applicant because the code allows for their equity interest to be transferred to their successor and for the record to still be considered a social equity record. When we don't have one of these on hand, we look for a court order, some probate decision or something else before we can make modifications. So it's in the entity's best interest and the social equity individual applicant's best interest to make sure that they have an up-to-date successor and interest form on file with the DCR, so that if anything were to happen, we would be able to make updates to the records while other, end of life situations play out. We did remove the requirement for the storefront retail commercial cannabis business and the micro businesses to have a county public health emblem placard by the beginning of calendar year 2026. However, we do have to work with the mayor and city council to amend the ordinance because the health emblem is a requirement punishable by a misdemeanor if they don't have it, or if a retailer doesn't have it as of January 1st, 2025. So that's something that we'll be trying to work with the council to get amended. And there was a lot of speculation as to what cease commercial cannabis activity means. So we added clarification within the rules and regs. The municipal code gives DCR the authority to not allow a licensee to renew a license when the activity has ceased for a period of 180 consecutive days. So what we'll be looking at on a go forward basis is the metric data to determine whether or not any cannabis related transactions have occurred within a 180-day period. In the event that somebody's going through a relocation, they're doing tenant improvements or something else, we still have the discretion to allow that licensee to continue to renew. But we do have a concrete rule now. So in the event that somebody has effectively abandoned their license or it's not being utilized, we can take the necessary actions so that compliant locations can be made available to other folks that are looking to actually operate. And then Regulation 9 was updated in its entirety based on our 2024 grant amendment and the audit results for some of our earlier grants. The biggest change was certain waivers that we had provided in the past, specifically for the social equity individual applicant fees, and then for the pre-application review fees. The state has come back and said that they don't agree that grant monies can be used for those, given the fact that it happens before an actual tangible application is submitted to the city. The pre-app doesn't result in an application being submitted. Somebody who's looking to get verified is not a social equity applicant at the time that they request verification. So the state has viewed those as administrative related tasks. So, on a go forward basis, we're not going to be able to provide waivers for that. And, the waivers that we will be able to provide is really going to be tied to application and environmental related fees. And with that, that's my update. So we can hop into the question and answer session.
Good afternoon. Hello, Jason. Our first question comes from Sherry M. And she asks, what is the process for adding a legal representative or contact to a record? Does an applicant need to pay modification fees in order to add a legal rep or contact?
So a modification request will have to be submitted through the DCR licensing portal. Depending on what record you're looking to add the legal rep or contact to is going to depend on where you submit the modification. If you're looking to add it for the business entity, you'll go into your legal business entity record and then submit a modification. For, legal representatives, consultants, neighborhood liaisons, there is not a fee to add that person as a contact, but you do have to submit a modification request. If you're looking to add a contact to a specific license or application record, you'll have to submit it on that specific record. You may have a neighborhood liaison that's assigned to one of your locations, but not another. So if you're trying to make license or application related contact changes, you'll actually do that on the commercial cannabis application or license record. And again, there's not a fee to add a non-owner, non-primary personnel related contact to the record. But if you are trying to do an ownership change, you're trying to add primary personnel to the record, an authorized agent who by definition has to be a primary personnel, there's likely going to be some type of fees for those forms and updates to be made within the system. But just for a legal rep, a consultant, a neighborhood liaison, there are no modification fees, but you do have to submit a modification record.
Our next question comes from Dennis B. Can you provide an overview of how the most recent regulatory changes might impact compliance requirements?
So hopefully I've covered some of that for you. The big regulatory changes are we're starting to do formal annual compliance inspections. And as we're getting out there in the field, there's going to be things where an operator is not compliant with our local rules and regulations. And as we're doing more of these inspections, when we see patterns, we review those types of rules and regulations to determine whether or not, um, those rules and regulations, are still beneficial at the local level. And in the event of like the motor carrier permit, the visibility of cannabis goods from, outside of the business premises, looking at the curbside delivery, those are things that, we were able to remove as violations, to make sure that we're as closely aligned with the state's regulations as possible and to allow businesses to, you know, utilize their license in the most productive manner possible. So it's just like any bureaucratic regime, it there's always going to be ongoing changes. There's going to be policy changes at the local level, policy changes at the state level, and primarily our goal is to align with the state as much as possible. So if the state adds a restriction or they take away a restriction, we would be looking to review it for the local impact. And if there is no detrimental local impact, we would look to update our regulations as necessary to realign with the state.
Our next question from Richard W. When will consumption lounges be allowed in Los Angeles?
That's a great question. I think from the department standpoint, we would like to be able to expand the ability for certain licensees to have on-site consumption and possibly introduce a new license type specifically for on-site consumption. But that license type and where that license could be located doesn't currently exist within our framework. So it's something that we've been trying to get policymakers comfortable with the hopes that a motion could be introduced to formally authorize DCR to accept that license type or application for that license type. There's some bills that were going on at the state level, and the passage of those bills could impact our regulatory structure. But similar to the Adult Use of Marijuana Act that legalized, adult use of medical sales within the state, it's likely something that a jurisdiction would have to opt into in order to authorize. So I would love to see consumption lounges in the city of LA within the next year or two, but ultimately it's not the department's decision.
Thank you, Jason. Our next question from Nick S. When will the lottery take place?
We're working on an omnibus amendment package to update the municipal code. We are making some recommendations to update the social equity individual applicant criteria. And depending on how long it takes for that, ordinance package to be considered and, whether or not the council votes to adopt it is really going to drive how quickly we can do a lottery. Our goal would be to do a lottery either late this year or early next year, depending on how some of those ordinance changes go forward. But there is no current date.
A follow-up from Nick S. What other activities does the lab testing license cover? In other words, how else can one use the lab testing license?
Our testing license is really restricted to testing activities. You can imagine that a tester shouldn't be allowed to also engage in other commercial cannabis activities for the products in which they're testing. It could lead to, test results that don't actually align with the products that are either being distributed or sold. So there is a firewall between the testing license and other commercial cannabis activities. So folks that have a testing license can engage in the testing activity, they're not allowed to engage in other commercial cannabis activities.
Nora K asks, why does it take so much time for different administrative departments to communicate and process information?
I mean, honestly, we're all just a big bureaucracy, and there's bureaucracies within bureaucracies, and different departments have different administrative rules and chains of command. And, unfortunately, as things that have to move through multiple departments kind of traverse those multiple departments, it leads to, in my view, unnecessary delays. There's not a specific like function or service that I heard in the question. There are different types of programs that are intended to help like small businesses navigate the city bureaucracy. There's a restaurant and small business express program. Commercial cannabis businesses should be able to access building and safety's small business express program, and that can help with some of the permitting. But ultimately, businesses can't go to DCR to initiate the permitting process for building and safety or fire, the public health permit. All we do is provide a clearance or an authorization for those other agencies to do what they need to do. If you go to the DBS website, there's some information about their case management process and how to request it. And either in the next Q&A or if you're in the actual Zoom meeting right now, you can drop a follow-up question in the Q&A section so that I know what service you're kind of referring to, so I can give you a little bit better guidance.
Michael W. asks, how do we reach out to DCR regarding the status of transitioning from a provisional to an annual?
I would recommend talking to your analyst. We have basically an aging report from the Department of Cannabis Control, and we're working through that list. And we started with the licensees that licenses expire in July. And then we're basically working our way through to the June licenses with the expectation that everybody who has a state provisional license will be transitioned to annual licensure at the local level about 90 days before your 2025 state license would expire. So your analyst would probably be your best bet in terms of where you would be at the local transition. But like I said, we've got an aging report that we're working off of to make sure that we have issued local annual licenses for everybody who's eligible by the date in 2025 in which the state provisional license would expire.
Moving on to Ron S. What is the prospect for a non-equity applicant to apply for a retail license? Has the city decided on a particular date?
I mean, at the moment, only social equity applicants can apply for the retail storefront license through January 1st of 2025.
Okay, next question from Gabriel A. When are the unincorporated areas going to be, I'm having a hard time with this question, going to have ordinances? Are there any licenses going on for unincorporated areas?
So the unincorporated county, like areas of the county, are outside of the city of LA's jurisdiction. We can only process applications and issue licenses within the city's boundaries. The county does have a department dedicated to the study of, commercial cannabis activities. And they are doing stakeholder meetings and preparing a report to go to the Board of Supervisors. But I don't know when the county will be starting to accept applications. But I do know that they are working on developing a formal commercial cannabis regime in order to deal with commercial cannabis activity in the unincorporated areas. I would recommend reaching out to the county for more specifics about their program and their program development.
Maurice C. asks, if an applicant received TA or temporary approval in the year 2023 and submitted all of its documentation, paid all of its fees to renew its TA for the year 2024, was the TA issued in 2023 automatically renewed on January 1st, 2024? And if you need me to repeat any of that, let me know.
I mean, it sounds like a question related to a specific record, so it should be best addressed by the, the analyst assigned to the record. If an applicant had, temporary approval in calendar year 2023 and they filed their renewal during the normal renewal period, which runs from the beginning of September to the beginning of November, they submitted all of the required documentation and they paid all of their, applicable fees within the normal renewal period, their renewal would be processed and there would not be a break in between the expiration of their 2023 license and when their temporary approval for 2024 occurred. That said, if you submitted one page of your 4013 form, or you didn't submit the indemnification agreement, or you filed and you didn't pay your late fees, or you didn't pay your original fees, it's not deemed to have been filed. So there could be a break in between when your license expired at the end of 2023 and when you actually met the licensure requirements for 2024. So there is no like retro, pass to cover, the period of time where you were not compliant. So if you submitted a 2024 renewal in February of 2024, your business would have been on license between, January 1st and whatever date your renewal application got processed and temporary approval was issued for 2024.
The next question comes from two individuals, Jesse F. and Tiffany W. Are there any updates regarding any upcoming grants for social equity applicants?
We got approved for our 2024 cannabis equity grant. The grant amount was $3 million. It was recently approved by the city council, and we're waiting for the disbursement of the grant funds. Based on the grant terms, only 10% of the amount can be used for direct, like technical assistance. So Dr. Brown and her team are working on identifying how that 300,000 would be utilized. And then, the bulk of the remaining amount, 2.67 million, would be used for some type of fee waiver program. And that's something that is currently being developed. The updated rules and regulations do indicate the types of fee waivers that would be available utilizing those monies. So if you have questions about specific fees or services, I would recommend looking at those updated rules and regulations to see how we had proposed to utilize those monies.
Ariella J asks, when will DCR issue notice of complete applications for non-retail records?
I would recommend reaching out to your assigned analyst We're in the final stages of having those 4013 forms routed to our bench of environmental consultants for them to begin preparing the environmental reports for those records. To date, we've really been focused on the records that are going before the Cannabis Regulation Commission because of the noticing that, requirements as well as the community meetings and public hearings. But we do anticipate that this summer, a lot of those non-retailers are going to start to move because we'll have consultants assisting us with preparing those environmental documents. If there's an operational need or something else, don't currently have the state provisional license, you can't operate. It would be something to discuss with your analyst to see whether or not we could expedite the environmental review for your project.
Anthony T asks, when will the next round of social equity verifications take place?
It would really depend on whether or not the city council adopts the recommendations that we're going to be making this summer. And then if they do, that'll really drive when we would reopen the social equity individual applicant verification process.
This is a follow-up from Anthony. What are the rules about people with medical referrals and the tax discount?
I would recommend reaching out to the state's CDTFA, which is the Department of Tax and Fee Administration, to discuss what types of programs and tax relief and what documentation you would have to submit. It's not a local program. At the local level, gross receipt tax is 10% for adult use transactions and 5% for medical transactions. But we don't have like any other type of local relief. So it would be best for you to reach out to CDTFA or to the Department of Cannabis Control so you can understand a little bit more about the state programs.
Our question from Hugo M. What does DCR social equity program help with? And for example, does it help with compliance?
So the local social equity program is focused on distribution of grant monies as well as providing business licensing and compliance assistance. Within that program, there's pro bono, low bono legal service assistance, fee waivers, fee deferrals, one-on-one coaching. And then there's a lot of content that's been posted to the learning management system. They do webinars, they do live and virtual events. So I would recommend reaching out to the SEP team to let them know kind of where you are within the DCR process and how to access different services that will assist you within that process.
Thanks, Jason. The next question from Heather C. Why did some social equity applicants receive another grant email and others didn't?
So trying to think of the most concise way to state it. But effectively, grant monies from prior years where we have already utilized the full allotment of grant monies to be used for administrative services have necessitated us to transition from having a third-party vendor administer the distribution of grant funds to actually bringing that on as an internal city function. So the social equity team recently asked for documentation from certain folks that are in the grant application process to get a vendor setup request form so that we could set you up with the controller's office so that we would be able to do the seed rental assistance grant distributions for any monies that you were eligible for. If you were not a seed rental recipient, or you didn't have a pending application during the transition from the third-party vendor to having the controller's office issue the distributions, you would not have received that email.
Um, let's see. Heather C has a follow-up. And why are the new grant forms not accessible? We had to ask for Google Drive approval and are still waiting.
So again, the forms are tied to internal city forms. There are drive permissions, and the social equity team can assist you with gaining access to the forms because, again, the email and the forms are intended to be targeted for the limited number of folks that have not received their grant distribution and won't be able to receive it from the third party vendor. So we need to have you set up with a controller's office. So the social equity team is managing the access to the form. And if you need it now, just please email the dcr.sep@lecity.org to get access to it.
Thank you. Nora O, what is the timeline to approve a location?
Assuming it's like a pre-app request and it's being done for like non-retail storefront activities, different members of the licensing team process as it gets assigned. For the retail storefront, there's a lot more that is involved with doing the review, looking at the locations, kind of looking at how the map changes day to day as different records are being acted on. And then we basically have a bottleneck for the review of the retail storefronts. So again, this is the type of question where either reaching out to your assigned analyst, or if you don't have an assigned analyst, reaching out to DCR licensing would be most beneficial because folks can actually look at a specific record and give you more targeted information.
From Mary J. If a license is proposing to add a new activity to an existing license and have gone through the pre-approval process, do we need to submit a new property diagram to the building and planning department?
Maybe it's going to be something that you'll have to talk to the Department of Building and Safety about. For licensees that are seeking new commercial cannabis activities, of course, you'll go through the pre-application review process, and then you'll submit the application for those activities. And then, we'll have to do the review of the premises diagram and everything else to determine whether or not you're eligible for licensure. If you're planning to do tenant improvements, you're doing construction, you're doing build out, you will have to reach out to the other city agencies to make sure you comply with their permitting requirements.
Mary J has a follow-up question. If a licensee is changing ownership of a partner from 60+% to 0%, but the other partners are staying on and the licensee's licensed with increased percentage, is that a possible scenario? And if you need me to repeat that, I kind of jumbled that up.
I mean, maybe, the only way to know for sure is to submit an ownership modification request and provide the documentation so that we can review it. For a general license that's not subject to the social equity ownership requirements in 10420, an existing owner could reduce their equity stake from 60% to 0 and sign the removal of owner form and then transition their equity to other owners on the record, and then of course submit the updated ownership or primary personnel forms and everything else. But if it's a social equity record and the social equity individual applicant owns 60% and the other owners are non-social equity applicants, that would not be a modification that would be approved by the department because the social equity applicant would fall below the minimum threshold for it to be considered a social equity license, which means that the modification request would be rejected. So it really depends on the specific record and, what rules apply to ownership modifications.
Logan F asks, will delivery ever be possible on Sundays within LA?
Unfortunately, I don't understand the question. So,
My sense of the question is this person is thinking that deliveries, business deliveries uh, of retail cannabis cannot happen on Sundays. That's
again, I'm not, I'm not, there's not enough information there. So
okay.
the person who asked the question is in the Zoom meeting. I would appreciate if they dropped a question that added more clarification.
Thank you, Jason. Moving on, Logan also asks about health permits, which cost $6,000 for 2 activities per renewal on top of licensing fees. Can there be any relief for the industry?
Unfortunately, the fees that were identified are not fees that, DCR has any control over. So we can't provide fee deferrals or waivers for other agencies' fees. So unfortunately, there is not relief for the public health permit related fees, building and safety fees, fire fees, planning fees, etc. We only have discretion to provide limited fee waivers based on grant monies received, and or consider people for fee deferrals for DCR fees in accordance with the department's rules and regulations.
Our next question comes from Danielle or Daniel S. Is DCR actively conducting pre-app land use reviews for Phase 3 Retail Round 2?
Provided the applicable fees have been paid, yes, we are doing that. We updated the sensitive uses on the public facing map earlier this week based on the May sensitive use list. We're in the process of rendering the layers for the retail storefront activities. And that will include the pending pre-op records that were in the department's pipeline. So one of the big things that folks need to remember are, we are not able to provide fee waivers for the pre-application review fee based on guidance from the state. Therefore, if you submitted a pre-app record and you have not paid the $597 land use review fee, your record's not being worked on, and it won't be worked on until the fee gets paid.
Our next question from two individuals, Daniel S. and Tiffany W. What is the expected processing timeline for pre-app land use review for Phase 3 Retail Round 2?
Generally, it would be 30 days from the time that the pre-op record is deemed filed. So all of the forms and fees received and complete if there's kind of something that happens with the review where we need additional information, of course, we'll submit a request and we won't be able to further work on the record until we get the information back. Um, if something is possibly too close to a sensitive use or another retail storefront business, we may need to get a premises diagram or other information so that we can continue our analysis.
Our next question comes from the initials TM. Will cultivation open up and what zoning types are eligible?
We don't have a timeline for reopening cultivation as part of our proposed ordinance amendments. It would be something that we would include in a lottery because there's probably only about roughly 100 opportunities still available citywide, and the fairest way to provide those opportunities to folks would be to conduct it through a lottery as opposed to like a first come first serve where folks are rushing to try to get in the door.
Okay, our next question from Arthur S. How is DCR and DCC corresponding with each other?
Generally through electronic mail, or we have monthly and quarterly meetings with the DCC, but a lot of the correspondence about specific application records go between the state analyst and the DCR analyst in terms of asking of what status updates are for additional documentation.
Okay, our next question is a follow-up to an earlier question that you wanted clarification on, Jason, from Logan. And my question regarding delivery was related to Regulation 5, 2 under responsible for management of business premises. For example, debris, no delivery or trash pickup shall occur on Sundays. I'm assuming that doesn't mean it's prohibited to conduct retail or wholesale deliveries on a Sunday.
That's correct. So yeah, thank you for that clarification. Businesses, licensees can engage in business on Sundays. So deliveries can be made to consumers. That regulation is like was restated. It's tied to the responsible management of the business premises. And it's really looking at the trash pickup and debris. For trash pickup, you have to be going through an authorized city vendor. For most parts of the city, it's the Bureau of Sanitation that does the trash pickup and loading, unloading, all of that stuff. And then there are some vendors that do it in limited areas of the city. But the intent there is that folks aren't doing trash pickup or giving you new bins or other things on a Sunday. I hope that helps.
Thank you, Jason, and to our attendee. Our next question comes from Tiffany W. What are current processing times for Phase 3 Retail Round 2, Elber's pre-app and temporary approval applications?
Generally, like 30 to 90 days for each of the different record types. If you have a specific record you're inquiring on, I would recommend reaching out to the department to see if you have any outstanding fees or whether or not you may be eligible for a fee waiver or what your specific circumstances.
Lindsay asks, why does the land usage process take so long?
The review for the retail storefronts, one, there's more sensitive uses than just schools. And two, we also have to analyze other records that are in the DCR pipeline. The land use review is dynamic. So, you know, as pre-apps get submitted, the requester um, is reviewed based on live data. And that data shifts day to day based on the activities and the records being submitted by other applicants. So you could have a situation where, you know, you know, somebody submits a pre-app review record in May and it's deemed eligible for further processing, and a pre-app record gets submitted by somebody else within 700 feet of that original location in June. Well, when the record gets submitted and while we're waiting for the June fees to get paid, the person who is deemed eligible for processing in may submit their temporary approval application or their annual license application, depending on the circumstance, at which point, you know, once they pay their fees and their temporary approval application is deemed filed, now they create a buffer around their location, which then, you know, would deem eligible the pre-app record submitted in June. So we've got, you know, over a dozen analysts that are processing records and looking at stuff. And we want to make sure that we get our land use reviews right. So again, every time we're looking at something, we have to look at all of the other records within that immediate area before we can make a determination.
Lindsay also asks, are there any grants to help me open my cannabis business?
We don't have any new direct financial assistance. Grant money is available. There's limited fee deferrals and or fee waivers that may be available to social equity applicants, depending on the activity. I would recommend reaching out to the social equity team to see what programs may be available to you. And then for general applicants, only folks that currently possess a state provisional license may be eligible for environmental review related fee waivers through the local jurisdiction assistance grant program. And of course, social equity applicants can participate in that program as well, as long as they have a state provisional license.
Question from Mike S. There are a lot of applicants who are eligible to submit a retail storefront pre-app. However, they are being slowed down in their property search, mainly because the data on the CPAs or per CPA has not been updated since November of 23. Will there be a update to the licensing map?
Yeah, the DCR team is in the process of updating the table.
Follow-up from Mike. Can DCR list each application's assigned analyst name and contact info on the Excel record?
That's an enhancement that we're looking to do. The data field that stores the analyst name is not a data field we can expose through the DCR licensing portal. So we're working with them to see whether or not it makes sense for us to create like a custom data field to copy that information into. And, you know, if we do make updates to the embedded data field, will that automatically update the custom data field? So it's something we're working with our software vendor on. And, you know, to that point, it would make it easier for folks to identify who their assigned analyst is.
Our next question from Diana A. Can an applicant submit a relocation and entity substitution request if they still need to receive the annual license? the applicant currently has temporary approval?
I mean, if a temporary approval has been issued and it's in good standing for calendar year 2024, a modification request could be submitted. They're not submitted together. So for the entity substitution, the entity that you'd be proposing, giving the application opportunity to, will have to have an active legal business entity record before we'll consider the substitution. And then for the relocation, that could be done under the existing entity, but if the desire is to do it under the new entity, you'd have to wait for the entity substitution to be completed before that entity could then submit a relocation request. You're not really going to be able to do them in parallel because we're going to need to have an application either for the new location or the new entity, and that will impact the ability of the existing licensee to operate.
Also from Diana, when will the land use review be completed for applications submitted 30 days ago?
To my knowledge, the deck of land use reviews will be cleared before the end of this week. And my team is updating the licensing map and re-rendering layers. So I would say within the next 2 to 3 days.
Thanks, Jason. Anahi asks, how long does it take to generate an invoice for the LBER? How much is an LBER invoice? And at what point is the LBER determined active for processing?
I would reach out to the licensing team if you have a specific record. The invoice for a general applicant will be different than an invoice for a social equity applicant because the social equity applicants go through the equity share review. And of course, the processing time to get to an active status is going to vary depending on what has to be reviewed on that record. It does take longer for social equity records to be reviewed because they do go through that equity share review, and there may be back and forth on operating documents or agreements to make sure that they comply with the municipal code.
And another question from Anahi. How do we process entity substitutions and relocation after an annual license is issued? Will DCC update the name for the entity substitution under an existing license, or do we need to reapply at the state level?
To my knowledge, you would have to reapply at the state level. But I would recommend reaching out to your DCC analyst to see whether or not they've amended their process for annual licenses. The entity substitution and relocation modifications are the same as they currently exist. But both of those modification types require the submission of a new application, which would have to work its way through the annual license application process.
Tiffany W. asks, is there an inspection checklist for the annual inspection process?
Right now, we only have checklists for the initial inspection, which is to get temporary approval. And then for the compliance inspections, the compliance team has been sharing stuff. For the final inspection, which is required to get an operating permit, the compliance team is working on that documentation in conjunction with other city departments that may have operating requirements that have to be reviewed as part of that final inspection.
The next question from Anahi. When will you begin reviewing annual applications for non-social equity, non-retail without DCC active licenses?
I would recommend reaching out to your assigned analyst. and kind of let them know what your standing is with the Department of Cannabis Control. For the key for me in the question was without a DCC active license. So if you don't have a active provisional state license, you're not eligible for any of the environmental review related fee waivers from LJAC. So there's going to be fees that you have not been assessed, and you'll be on the hook for paying your annual license application fees for the activities, the environmental review fees, and other stuff in order to move forward in that process. So if you believe that you're ready to move forward through the full annual license application process, you can work with your analyst and they can generate an invoice for whatever applicable fees would be due. And then, of course, once those fees have been paid, we can move you through that process.
Jason, I was just noticing the time and wanted to check with you. It looks like we have 4 questions in the queue and about 3 minutes left till 1 o'clock.
Let's get through the questions we have in the queue.
Okay.
Thank you.
No problem. Anahi asks, how often is undue concentration for cultivation updated on the licensing map?
I mean, not very often. We're not accepting new cultivation applications at this time. And the folks that had the ability to apply for cultivation, whether it was through phase 1 or phase 2, are not subject to a finding of undue concentration for the application that would be pending before the department. So really, we look at that data when we're considering relocation request to try to determine whether or not a community plan area is subject to the finding or not, because that drives whether or not we can process the relo request. But other than that, because we're not accepting new applications and the folks that are in the application queue, those applications can be issued licenses regardless of whether or not the CPA reaches undue concentration while the application is pending. It's not a priority for us to update it.
From MS, please elaborate on the city's proposed amendments related to the health emblem. Does the city currently know if retailers can operate on January 1st, 2025 without an emblem?
I mean, based on the municipal code, a licensee that does not possess an emblem on January 1st of 2025 needs to cease conducting commercial cannabis activity, or at least the retail activity, until they get the emblem. And the municipal code sets that as a violation of a misdemeanor. So there could be enforcement actions taken by LAPD in conjunction with the city attorney's office for retailers that fail to abide by that requirement. Again, that's something that we will be proposing to amend so that folks can continue operating while they work toward getting their emblem. But that will be a policy decision that has to be made by the mayor and city council. But it's something that the department thinks is an urgent amendment that needs to be taken up. So hopefully when council comes back from their summer recess in August, we'll be able to get those amendments before them for policy consideration. And if they adopt it, we would work with the city attorney's office to get the code updated before the end of the calendar year, before it goes into effect. But stay tuned.
Okay, next question from MS. If a phase 2 cultivation license currently has a social equity individual applicant, are they able to transfer their equity to a non-SEIA? And does the answer to this question depend on whether the current record has gone through equity share review?
All of the above, and it would also depend on whether or not a license had been issued. You know, the best way to get a more defined answer would be to reach out to your assigned analyst or send us an email so we can look at the specific record.
And then the last question, I think it was answered before, but I'll ask it. Mark, are any storefront opportunities coming for social equity applicants?
There's still citywide capacity. So our ability to get some of those amendments before the council and then to set up a future lottery will really drive how quickly those application opportunities could be made available to social equity applicants.
Thank you, Jason. That was the last one in the queue.
Thank you. So I want to thank everybody for coming today. Our next Q&A virtual lunch will be on July 10th at noon. July 10th is also a Wednesday. We will be doing a Cannabis Regulation Commission meeting on Wednesday, July 17th, which is why we had to bump it up earlier in the month. So thank you all for your participation, and I look forward to answering questions and giving you an update next month. Take care.